welcome. My name is Colin Starger. I'm a professor here at UB Law, and I am very pleased to welcome you to this afternoon's webinar and book talk with Professor John Bessler to discuss his latest book, Private Prosecution in America. This book is the first comprehensive examination of an American practice that dates back to the colonial era, but it has its origins much earlier than that, and the book masterfully tracks its origins to medieval times and English common law. The book shows how private prosecutors were once a mainstay of early criminal procedure and persist to this day in one form or another. Private prosecutors, acting on their own behalf as next of kin or through counsel-initiated prosecutions, presented and present evidence in court and sought the punishment of offenders. Though old and very well established in many ways, John raises serious questions about whether this practice should continue, both as a practical matter and as a matter of constitutional law. Indeed, he argues that the practice is unconstitutional. So we're very happy to have an esteemed panel joining us for today's discussion. The way it's basically going to work is John will present about the book, give some background and context, and then we'll have the reactions and comments from our different panels. Those panelists are Dean Roger Fairfax of the American University Washington College of Law, Professor Kim Whaley, and Professor Dave Jarros from our law school. So before we begin, I'd like to very briefly offer biographies of each of the folks, and then hand it over to John to tell us a little bit about our book. So I'll start with John. He is a professor of law at UB. He teaches capital punishment, civil procedure, contracts, international human rights law, and ILS, our Introduction to Lawyering Skills, among other classes. He has written or edited 11 books, 6 of which are on the subject of capital punishment, which he is an internationally recognized expert. And several of these books have won book awards. And in 2018, he received the prestigious University System of Maryland Board of Regents Faculty Award for research, scholarship, and creative activity. So that's a very prestigious award and well-deserved. And on a personal note, I'll just say that John is a wonderful colleague. He's very generous, extremely hardworking, and really a heck of a nice guy. The next person that I'd like to introduce is our esteemed guest, Dean Roger Fairfax from American University Washington College of Law. He is a prominent legal scholar, educator, and nationally known expert on criminal justice. He has previously served as the Patricia Roberts Harris Research Professor and founding director of the Criminal Law and Policy Initiative at George Washington University Law School. His scholarship has been published in books and leading journals, and he has taught courses and conducted research on criminal law and procedure, professional responsibility and ethics, criminal justice policy and reform, racial justice, and the grand jury and internal investigations. And he also knows a thing or two about private prosecutions. So we're so glad that you can join us. Thank you so much, Roger. Next is Kim Whaley, our very own, who teaches administrative law, civil procedure, and federal courts here at UB Law. She'll also be teaching constitutional law, which she is an expert. She has special interests, including separation of powers questions and the constitutional implications of structural and technological innovations in modern government. Notably, she's a frequent legal analyst on CNN and other news outlets. You can often see her on TV or hear her on the radio, and it's wonderful to see her out there like that. She is a regular and engaging columnist for The Bulwark, Politico, and The Atlantic. So welcome, Kim. And last but definitely not least, David Jarros is the faculty director of the law school's new Center for Criminal Justice Reform. He teaches criminal law, criminal procedure, and evidence. His scholarship addresses the use of criminal law to police and regulate various aspects of our daily lives. He's also an appointee to the Maryland Task Force to study crime classification and penalties. And I think it's safe to say that he's probably the funniest person on the UB faculty. So that's who we have. It's a great panel. I'm really excited. And I'd just like to turn it over to you, John, to begin and tell everybody on the webinar today a little bit more about your book.
Great. Thanks, Colin. I appreciate that introduction. Very kind. And I want to thank the panelists for participating, and especially our special guest, Roger Fairfax, who I actually got to know a little bit at GW when I taught there for a couple of years as a visitor. And Roger's written in this area, and I'll explain a little bit later about that. But I wanted to introduce this topic. A lot of people don't really know much about private prosecution, wouldn't even know what that is even, but it's something that, as Colin said, does date back to medieval times and certainly colonial times. It was really the standard way that cases were prosecuted in England. And when we talk about private prosecutors, we're really talking about two different ways in which that term is used. One is the private prosecutor was referred to as the term used for the victim or the victim's family that was in charge of prosecuting the case originally in England. Or today, we sometimes talk about private prosecutors as the private lawyer that's hired by the family of a victim of crime to prosecute a case. So this book was more than a couple of years in the making. And if we think about I'm trying to get my PowerPoint to work here. Let's see.
You might need to click on the screen once, John.
Okay. Oh, here we go. All right. So I originally looked at this topic back in the early 1990s. Actually, I was working in private practice. I wrote a law review article on this topic, really arising out of some work that I did with Sandra Babcock, who's a lawyer now, internationally known lawyer who does death penalty cases and other kinds of work. And she's now at Cornell. At the time, she was a Hennepin County public defender. Before that, she was working at the Texas Resource Center. So she had a connection to Minnesota, where I was. And she actually had a couple of cases, and I've cited them here, the Joseph Stanley Falder case and the Wayne East case, both of which were capital cases that involved private prosecutors. These are prosecutors hired by the victim's family. And in one case, I think the public prosecutor was off playing golf while the private prosecutor was taking charge of part of the criminal case. And these were in the Fifth Circuit. These were litigated cases that resulted in opinions. This is a decision from 1968, Powers versus Hawk, which quoted with approval the district court's conclusions of law that basically said as long as the district attorney, the public attorney, retains a control and management of the prosecution, then the special prosecutor or the private prosecutor is not guilty of conduct prejudicial to the defendant, and doesn't require reversal of the case. And that was basically the thing that we were challenging and saying, no, that should constitute a violation of the defendant's rights. Powers versus Hawk was the first case of the Fifth Circuit to expressly address whether the participation of a private prosecutor was a violation of the due process clause. In Powers, that was, again, a habeas case involving a capital murder charge where the victim's family had hired that private prosecutor. This is one of the cases that Sandra handled back in the 1990s. And this is the other case, Falder versus Johnson, in 1996. In that case, the court said that there was no per se constitutional prohibition against the use of private prosecutors. But the court did raise some concerns about when you have somebody who's both being paid for by the murder victim's family and who's purporting to represent the public interest for the public prosecutor's office, you have a conflict of interest, and that can be of concern. In the case of Mr. Falder, he was actually executed by the state of Texas in 1999. Roger Fairfax comes in here. Roger actually invited me to speak at who's one of our panelists here today, and who's graciously taken his time from his dean work to join us. Roger had invited me to give a presentation at the SEALS conference, the Southeastern Association of Law Schools conference. And originally I thought, well, I'll just update the work I did on my law review article from 1994 and produce some new law review article. But as more I looked into it, I realized there still had not really been a book on the topic. I decided to dig in and write a book about the topic. And so thank you, Roger, for for the 2 years I lost, or I gained information during that 2-year period. But it was a real effort to put the book together. But I do appreciate the opportunity to speak at that conference, which is what led to this book. So I want to give people just a quick history before we get to our panel and kind of go through a little bit of the argument in the book. This practice, again, dates back a long time. So we had originally something called trial by battle or trial by combat, as it was referred to, where people would actually basically fight it out. This was an alternative method to what we think of today as trial by jury. So today we have juries decide. Back then, they would actually, choose weapons, and they would fight, and sometimes it would lead to the death of one of the contestants. Here's an example here of a trial by combat from 1409. So you can see that what the practice was back then for trial by battle. In England, the criminal justice system really allowed private prosecutors to commence criminal cases, and they did that by bringing what was called an appeal. An appeal then is not what you think of as today as something where you're having a higher court review what a lower court had done. It was actually a way for a private person to essentially commence a criminal action against another private person. The public authorities, the English Attorney General, the Crown could bring an indictment or an information, but there was this method of an appeal that could be used. And that was actually transmitted to the United States, or originally to the colonies in Pennsylvania, Maryland, elsewhere. I found a case actually from the 1760s where an appeal was used in Maryland before the Declaration of Independence was issued. Here's James Wilson, one of our founders, signer of the Declaration of Independence, saying what an appeal is. So an appeal is an accusation by one private person against another for some crime. It is a private action of the party injured, demanding punishment for the injury which he has suffered. It is also a prosecution for the state on account of the crime committed against the public. Interestingly, there was no double jeopardy protection for this, so that if the public authorities brought a prosecution that was unsuccessful, the private person still had the right to bring that same prosecution, potentially get a death sentence. That's exactly what happened in the Maryland case in the 1760s. England abolished a trial by battle back in 1819 after a decision in Ashford versus Thornton, where the Court of the King's Bench said that it was still permissible to have a trial by battle. There was a case in which Abraham Thornton threw down his glove and challenged the person who accused him of the crime to fight it out, essentially. And so the next year, they decided to abolish trial by battle. The court in that case in 1818 had said that was a permissible way of resolving a dispute. And obviously the Parliament decided to change that. In the United States, we actually had a long history of private prosecutions. I'm just going to mention a few of them here. There was a murder case in Salem, Massachusetts. There was a sea captain who was murdered in his bed and was a very wealthy individual. And there was his name was Joseph White. And so there was a big case involving that. One of the people committed suicide. There was two different sets of brothers who were involved, the Crown and Shield brothers and the Knapp brothers. The Knapp brothers ultimately would be executed as a result of a private prosecution that was brought and led by Daniel Webster, who was then a sitting U.S. senator for his state. There was a challenge to his participation in the case. He was actually paid a $1,000 fee, which was a large sum of money back then, to handle the first case. There was no objection in the first case. In the second case, they did object after he got a death sentence in the first case, but the judges decided he could participate. Here's the lawyers objecting. They didn't want him to participate in the case because he was actually being paid by someone who had an interest in the proceeds of the inheritance of the man who was murdered. And so this is a case from 1830. Here's the newspaper articles about the sentences, and one case, the execution. Both of these young men were executed in Salem. Abraham Lincoln was involved in some prosecutorial work a few times. Mostly he did defense cases, but he did a couple of cases. Again, he was wouldn't describe him necessarily as an interested private prosecutor, but he was appointed to handle cases and was operating as a private lawyer at the time. And so he handled a couple of private, what we would think of as private prosecutions, although they were not interested private prosecutions. Daniel Sickles was a congressman in New York who was charged with murdering Philip Barton Key, who was related to Francis Scott Key. Philip Barton Key had an affair with Daniel Sickles' wife, and he was shot just not too far from the White House, actually. And it was a murder case. There was an insanity defense, but that also involved a private lawyer that was involved in that prosecution. And back through history, we've had both private policing and we had private prosecution societies. These were formed to prosecute criminals. You can see the history of this through some of the images here. And you look to see how the courts have talked about this, right? Private prosecution is something that comes from the English common law practice, again, of having the victim or the victim's relatives, could be an heir, could be somebody closely related to the victim who ends up handling the prosecution. Here's an image of the Old Bailey, which is actually a street for which the Old Bailey, the Central Criminal Court of England and Wales, is named. And we had a lot of private prosecutions there. I look back several centuries, you could find lots of private prosecutions in England. One famous one was Oscar Wilde, who commenced a prosecution against the Marquess of Queensberry, who was a Scottish aristocrat who was very homophobic and was harassed Oscar Wilde. Oscar Wilde had a relationship with the aristocrat's son, and the aristocrat did not like that. He was actually also associated with what are called the Queensberry rules, which were the rules for boxing, actually, that he promoted. And he had a reputation for being very volatile, very violent. Actually came to Oscar Wilde's house at one point, threatened him. Oscar Wilde ended up commencing a private prosecution to try to vindicate himself. There was a calling card, I showed that at the beginning, where the aristocrat had said that Oscar Wilde was basically posing as a sodomite, and he misspelled the word sodomite, but that's what the accusation was. Oscar Wilde was having relationships with young men. That came out over the course of the case. Eventually, Oscar Wilde withdrew his private prosecution. That led him being prosecuted, and he then later was convicted. After he was arrested, he was prosecuted, convicted, and imprisoned for a couple of years. Really ruined his life. He was at the height of his fame at the time with theater productions in London, and this case really ruined his life in terms of what happened. So we think about private prosecution today versus public prosecution. Just a quick snapshot. The first statute was from Connecticut, required public prosecutors, was in colonial times in 1704. In contrast, this is a statute from Kansas that's still in effect today, which says that the prosecuting witness may employ an attorney to assist the county attorney and can appear with the county attorney in a criminal case. This was applied recently to allow a private lawyer to associate in a capital case in Kansas. We did have some jurisdictions that decided they didn't like this practice. This is one decision from Wisconsin from 1888, where they said you should not have paid attorneys for private persons appearing as prosecutors. By 1906, Roscoe Pound gave a big speech. One of the lines there was private prosecution has become obsolete. It was moving out. There was a professionalization of public prosecutors' offices. And here we see the model rules of professional conduct. Prosecutor is supposed to be a minister of justice and not simply an advocate. And that's an important principle. Just a couple things in the law here. There's some decisions that have found that this actually does constitute a due process violation. And this is a quote from a case in New York, People versus Calderon, that so held. It referred actually back to a case called Young versus United States that was decided in 1987. But this case was decided on the basis of the supervisory authority of the court, not on the due process clause. But it concluded that a private attorney appointed to prosecute criminal contempt should be as disinterested as a public prosecutor who undertakes such a prosecution. And more recently, we've had an opinion written by Chief Justice Roberts in Robertson versus United States, ex rel. Watson, which was they were dissenting from dismissal of cert, and they were raising questions there about, again, the due process clause and talking about how the due process clause guarantees certain rights because the prosecutor is a state actor who's carrying out a duty on the part of the government. But if the criminal prosecution is instead viewed as a private action, then how would certain rights attach? And a couple of the rights that Justice Roberts refers to is the obligation to turn over exculpatory materials, Brady materials, and also the idea of getting Miranda warning. And so that's kind of where we are right now. We don't have a Supreme Court ruling yet on the due process issue. Justice Blackmun in the case of the Young case did have a concurring opinion where he said it did rise to the level of due process violation. And that's kind of what I've been arguing for in this arena, is to have a due process ruling on that point. So I think I'll stop there and we'll leave time for the panelists and questions.
Thanks so much, John. That's super informative, and it's great to see all the original pictures and old newspaper clippings. The book is very long. It doesn't have any pictures. It's great to see them now. So for our first reaction, let's turn it over to Dean Fairfax, and we'd just love to hear what you have to say about it and what you think the appropriate role for private lawyers is in America's criminal justice system.
All right. Well, thank you, Colin. And I'm just honored to be here to discuss this phenomenal work by my friend, John Bessler. And as he mentioned, he was visiting at GW. And I think at the time I was the most recently hired entry-level faculty member. So we had the two worst offices at the law school, but they were close together. So we got a chance to bond, and we've kept it in touch since then. And also, I want to thank you, Colin, and Kim, and David, and Christine, and also, thanks to Ron for letting a fellow dean hang out with your outstanding faculty. And I have so many friends here on the Baltimore faculty. So this project, as Colin just said, is lengthy. It's weighty, and I usually hold up the book whenever I'm talking about a book as a prop, but I have to use two hands for this because it's weighty, literally and figuratively. And 430 pages of text, almost 500 pages of notes, single space, thorough analysis in the notes. They're not just citations, but there's a lot to wade through in the notes, and it's just a tremendous effort and result, John. So I congratulate you on the book. And as John noted in his talk and also in the book, I wrote on private prosecution earlier in my career, probably 12 or 13 years ago, and I largely explored it through the prism of outsourcing, one of Kimberly's areas of expertise, and I look forward to hearing her comments as well. And I relied on the then growing literature on the private role in criminal justice. Most notably, we saw a lot of writing in the policing and the prisons areas. So I relied on the work of people such as Elizabeth Joe and David Sklansky and Sharon Dolovich are some of the names that come to mind. But more directly, in my work, I was questioning private prosecution, whether outsourced, to private actors by governments, or in the context that's primarily the subject or focus of John's book. I question it from a democratic legitimacy standpoint, right? And so I was advancing ethics and due process and accountability critiques alongside questions regarding sovereignty and public prosecution norms. And I was generally sour on the enterprise of private prosecution, but recognizing that it would likely still exist in pockets around the country. I tried to offer some suggestions for mitigating its negative effects. And among these were permitting the private exercise of ministerial functions associated with prosecution while preserving the discretionary functions for government actors. Another suggestion was better guiding exercises of discretion by private prosecutors, like cabining their discretion and providing guidelines for the exercise of that discretion. And then also promoting transparency in decision-making. by private prosecutors. And just as a note, my work done in this area was just before I really became engaged in the American Bar Association, the criminal justice section's a standards project through my service on the section council, and also just before I began teaching legal ethics. And I actually designed a professional responsibility course that focuses on prosecutorial ethics and criminal defense ethics. And so I was teaching the model code and model rules through the prism of criminal practice. And had I been doing that at the time I was engaged in that scholarly work, I likely would have placed more emphasis on the ethical rules and standards as John has. But John really has done a great job in this book of covering all of that ground and so much more. What jumped out at me is, and you'll have to understand that I am a grand jury geek. I am someone who loves the grand jury. I may be one of the very few people who thinks that the grand jury is something worth studying and has a significant role to play in our modern criminal legal system. But in my research agenda, which has been dominated by my study of the grand jury, one thing I had not gotten around to is the relationship between the evolution of private prosecution and the role of the grand jury. I've always been fascinated by it, something I had always intended to look at, but never got around to it. And in reading John's wonderful book, I found a treasure trove of insight on this relationship between the grand jury and private prosecution as it evolved. And I loved, John, that you talk about that the era where we had trial by battle or ordeal. One of my favorite that I read about was trial by morsel, where they literally stuffed a wheel of cheese down someone's throat, and if they didn't choke to death, then they were not guilty. I mean, that's the level of criminal procedural protections we were talking about here. And so the development of these institutions was so important. And as I teach my students, in the 12th century, we had a couple of significant developments around the essays of Clarendon and the constitutions of Clarendon. And these were really tools that were used to mediate tensions between the crown and the feudal and the ecclesiastical realms. And it's how do you sort of mediate and moderate these tensions? And so this structure was put into place, and we saw the beginnings of what would become a two-tier jury system, where you had an accusing jury and then you had a petit jury that determined guilt or innocence. And I really appreciated it in the book, John, when you went through Blackstone's definition of the grand jury and the true bills and the role of the grand jury in issuing no true bills when they ignore accusations. I thought that was important context, as was your very careful explanation of the differences between Scottish practice and English practice, right, in terms of public prosecution and the Lord Advocate role in Scotland, which had no grand jury, which was also very interesting as well. And then, you really, I think skillfully trace England's shift from private to public prosecution, and you use the director of public prosecutions sort of as an anchor for that explanation. But, again, you explain that private lawyers still brought cases before the grand jury, even as this DPP role was evolving. One thing I did not know and was fascinated by was your discussion of the Vexatious Indictments Act of 1859, right? Which limited the rights, as you explained, of private prosecutors to bring matters directly to the grand jury. Instead, they had to go to a magistrate first, and then the matter could go to a grand jury. And the concern there was that private parties would seek indictments to extort or oppress the accused. And it reminded me, when I was at the Justice Department early in my career, working for the head of the criminal division. This was just after the Hyde Amendment was passed, which created a cause of action for prosecutions that were brought in bad faith or were vexatious. And so actually that same language was used there in the statute. And again, it was sort of getting at the same concern, although obviously in the latter case, it was in the context of a public prosecution. I also really appreciated your discussion of county prosecutors and how it really was an adjunct or supplement to private prosecution. It didn't displace private prosecution. And I think the nuance here is important because, as you explained, private parties were still responsible for the investigation, right, and bringing the complaint to the magistrate. And even on some occasions, as you point out, they were responsible for the grand jury presentation before the public prosecutor ever stepped in, right? Even though we had these public prosecutors, these private parties were doing all of the work. And in some jurisdictions, as you note, the grand jury indictment had to have the name of the private prosecutor endorsed on it, right? So it just shows you how integrated this private prosecution was, even in the evolving public prosecution infrastructure. I also, this was another thing, because I'm fascinated with the enforcement of criminal law shortly after the ratification of the Constitution. I think there are lots of gaps in our understanding there. And I think this is a tremendous contribution that you've made there, including that private citizens were still presenting directly to the grand jury in the early years after the Constitution was ratified. And you provided, I thought, a sound explanation, and that's because most of the common law criminal offenses that we had there, they were, number one, they were mostly common law criminal offenses, and they were very tort-like in character, right? They involved injuries or wrongs that were directed at individuals or at their property. So I thought that again was another tremendous insight there. Although that, there was, I think, a quicker movement away from private prosecution in the federal system. Those early years are fascinating. I was also fascinated by the fact that so much of this seemed to be centered in Pennsylvania, and you talk a bit about that. Lots of Pennsylvania jurisdictions, and you had a lot of great tidbits coming from actual cases. You rely heavily on primary sources, newspapers, case files, and the like. Something that came out of that analysis was what the system did to respond to the concern around frivolous private prosecutions and how costs were being imposed on private parties to try to deter frivolous or oppressive prosecutions there. But another thing that surprised me is that sometimes these costs were imposed on acquitted defendants and split between them and the private prosecutor. So defendant has been acquitted and is still assuming costs in these cases. And then again, as a grand jury a geek, as I described myself, I loved the discussion of grand jury charges and how these convening judges, both in the late 19th century and the early 20th century, would charge grand juries and would use those charges as they had been used throughout American history to make political statements, right? There's a long history of that. But in these situations, they would use the grand jury charge to express their skepticism about private prosecutions. And then your analysis of the arguments made by lawyers at trial, right? Arguments made to the jury, casting doubt on the allegations because it came from a private prosecution, again, was something that I thought was particularly fascinating. So I'll just close with this. I mean, there are a number of phenomenal scholars doing important work in this area. Some that come to mind are my former student, Russell Gold, Bennett Capers, I think has done some great work in this area. Maybelle Romero, she's had some very interesting scholarship there. And they actually were all part of that SEALs roundtable that John mentioned. But really with this book, John Bessler has produced the definitive work on private prosecution. It will be the source that generations will turn to for guidance on this topic. And I'm just honored to be a part of this wonderful celebration of this achievement. So thanks for having me, and I look forward to hearing from my co-panelists.
Thank you so much, Roger. And I think you've really demonstrated, one, why we were so thrilled to have you as our honored guest, but two, the level of detail and contribution to the scholarship that John's book has really brought. And like you say, how it will be a resource for generations, and really appreciate how much you were able to elucidate that with specific examples. I'd love to turn now to Kim, and Roger had sort of alluded to your work in government outsourcing, and I thought I might ask you to react to the book generally, but also in the context of how that phenomenon of outsourcing helps us maybe understand some of the stakes at play in this discussion.
Well, thanks, Colin, and thank you for the invitation. Congratulations, John, on the book. It's really incredible. I want to put it on my coffee table because I'll seem smart, not only that I have it, but that I know who wrote it. And, you know, the 11 is amazing, and so much on the Eighth Amendment and the death penalty. And I've got to imagine all of that work informed this, right? Because we keep going back and over again these days to the Due Process Clause, right? Which goes back to the Magna Carta, 1215, where there was a negotiation with the king and the sovereign as to certain basic rights, that you can't take someone's life or liberty, can't execute them or put them in jail without some basic procedure, because as you indicate, way back then, the king plus the church was the law. Right. And so there really wasn't an established criminal code. People kind of duked it out, Game of Thrones style, as you so, I think, in a fascinating way depicted for us. And it's hard for us to grasp that in this moment, that's what the common law underpinnings were, that the king would give justice as the king or the queen decided. But basically, it was dog eat dog. And I think it's really, really interesting that it wasn't until the 1980s that we have some of this codified, that private prosecutors are a problem. I'm also going to circle back because Roger so kindly mentioned my work, but frankly, it was your piece that got me started, I must say, reading back at GW. I think that's when John and I met each other, was when we were visiting at GW. And truth be told, I think I ended up expecting a child, my fourth, and I think John came up to Baltimore to cover that semester, and we got extraordinarily lucky to have him all these years later. So it's the full circle is really amazing. To Colin's point, what's really interesting. From Roger's work, what I started working on was this concept of outsourcing in the Constitution. That is, so students of constitutional law, separation of powers understand we have three branches of government, and each branch does its job, and the other two branches grade the papers of that branch, right? But we've got a situation where when Congress creates a executive branch agency that isn't controlled by the president, the Supreme Court gets upset. Right? The Supreme Court starts striking down these independent agencies on the notion that the president should have a lot of power. On the other hand, when executive branch agencies enter into contract and negotiate some kind of deal with a private actor, whether it be Halliburton or Booz Allen, the Constitution falls off the radar completely because it's not state action. And it just fascinates me that we have so much concern about state actors acting as state actors. This Supreme Court is going to decide this summer whether to revive the non-delegation doctrine, the idea that Congress can't even give agencies the authority to make laws. Well, agency laws don't put people in jail. and they certainly don't send people to the execution chamber. And so it's so interesting in my mind that we're having this debate at the same time. We're still seeing, when it's talking about life and liberty, private actors that are still in play. On the other hand, so much focus on this idea of too much regulation by entities that are government entities and are accountable to the president at the ballot box in theory, and also bound by the United States Constitution. So I'll just say what John is doing, and I agree completely with Roger, this is a seminal work. It's one that when years ago when I started thinking about this, nothing even close to this existed. But I think the implications of it are so much broader. So John is talking about the apex of government power, the ability to put someone in prison or to take their life, and outsourcing that, giving it to private entities who have different incentives. Maybe it's financial. You mentioned that. Barbara White, our colleague, said $1,000 then was $30,000 today. It creates different incentives if someone is going to make money off of putting somebody in jail. So you're establishing that the conflicts of interest in that situation, the problems, the disincentives, and then let's talk about, okay, how much of the administrative state is actually being administered by private actors for whom there is no constitutional accountability absent the state action doctrine, which is so difficult to trigger. So great example, again, not criminal context. You go to the airport, you get groped by a TSA agent. If they happen to be on the payroll of the federal government, you have a constitutional claim. If they're on the payroll of a private contractor, you have no constitutional claim. It's just in tort. So I hope that this discussion can sort of in a logical way make its way into some of these other conversations around the scope of government power. The other thing I think is so interesting is what we've seen, frankly, in the last few years around other ways in which government is outsourced. Of course, I'm thinking about the appointments clause, and just hiring friends, hiring sons-in-laws, hiring private lawyers to act as diplomats, to make decisions about pandemics, to use recess appointments and bypass Congress. We're in this phase where I think this debate between government power and private power, who actually holds the reins, how much of it is transparent, and what measures are in place to actually cabin that? Because in theory, the idea is, of course, in America, under a democratic constitution, we're the bosses of our people who are in power, and we can make that decision at the ballot box. And of course, if it's a private actor, you can't do it at the ballot box. It's a completely different incentive. So that's, I think, another theme that I'd be interested in hearing John talk a little bit more about, perhaps the idea of whether other ways in which the private sector is infiltrating government. For you, it's, in your book, it's the most extreme examples, people going to prison again, or to the execution chamber. But we're seeing, of course, last week, we're even potential conflicts at the Supreme Court level around democracy, other types of things. I think this whole conversation surprises many people. This idea that actually the private sector does have a tremendous amount of impact on government. It's not accountable to the people in the same way. And what, if anything, should be done about it? Where are those checks and balances? So I'm so appreciative of this amount of work, in addition to, as I said, the Game of Thrones scenario, which I can't help but pick on Rudy Giuliani, who said the Game of Thrones was about the Constitution or something like that, or maybe it was about common law England. So with that I'll wrap it up and pass it along to my colleague Dave. But thanks again for having me.
Thanks so much, Kim. And I think you've a perfect bridge between Roger and you is both. It's both about history, but that history has implications for today as we try to unravel and relate it. And I think you set that out so well. And so let's turn now to Dave. You've just started a new criminal justice center here in Maryland, and I wonder if you might give us a little of that perspective on what this book generally can tell us about the criminal legal system, and specifically in Maryland.
Thanks. I just want to say that I'm grateful to be here, and I'm grateful in part because of Roger, because I've known for years that in a world of trial by battle that I was pretty much screwed. But now that I know there's trial by morsel and all I need to do is take down cheese, I feel like I have a shot here. So this is really wonderful news, and I appreciate that. I can't say enough about the book. I think many readers of this book would be surprised, and I mean even shocked, that by the role that private prosecutors have played and continue to play in the American criminal legal system. If this book were just that, if it was just a detailed description of how private and public prosecution has developed in America, the shift over time, and the degree to which vestiges of the private prosecution system continue to this day, I think in and of itself that this would be an incredible contribution, John, and I am thrilled to have you as a colleague and the fact that you wrote the book. And I know that there are people who are going to argue that, look, when you get rid of the notes, it's a mere 430 pages. But I'm going to argue that there's another reason that this book should be read and that it should provoke deep discussion. So one way to view the book is that it identifies the existence and source of what I think John describes as a deeply troubling practice, private prosecutions, that raise complicated issues of ethical concerns and problematic incentives that almost definitely exacerbate many of the inequities that plague the criminal system. And your examples, which Roger talked about Brady, the possibility of unequal treatment, of bias, class, and race, all of that come to the fore. And my first reaction to the book, frankly, was simply shock and dismay that private prosecutions sort of persist. But I also think there's something else here. And I think that private prosecutions highlight a fundamental issue that we continue to wrestle with in the criminal system. And that issue is, what is the proper role for victims in this process? And to what degree do victims get to make decisions about using the power of the state to punish? And I think a necessary corollary to that question is, how much power and discretion over the criminal justice system do we want to vest in prosecutors and the state? And that is an issue I think we continue to wrestle with. And I want to talk about Maryland. So Maryland no longer has the full private prosecution, as John explains in his book, but we do allow private citizens to initiate a criminal case by filing what's called an application for statement of charges. If you Google the term application for statement of charges, the first thing that pops up is a PDF from the Maryland courts that explains exactly how a private citizen can initiate a criminal case against someone else. All right, and it lays out where on the form you write down the facts, and then you give it to a county court commissioner. And if that county court commissioner finds that there's probable cause to believe that a crime was committed and that a particular defendant committed that crime, they can issue a summons or a warrant for arrest for that person and initiate the case. And notably, those court commissioners are empowered to issue orders of protection that can expose that defendant to criminal charges were they to violate that. I mentioned this when I heard about this book to a former Maryland prosecutor, and he said, "Oh yeah, prosecutors hate that. It's always one neighbor filing a case against another neighbor based on some fight that they've had." And he said that the prosecutors routinely decline to pursue those cases. So in Maryland, a victim, and it's important to note, when we say a victim, it's a person who believes themselves to be a victim, because obviously there's got to be determination that there was a crime and that they're in fact the victim, but I'll call them the victim. So the victim can initiate this case, can start the criminal process moving, but the prosecutor retains the discretion and control to decide whether or not the case will continue. And I think John's book provides some perspective on both why we tend to think that victims perhaps historically, and maybe continue to have it be appropriate, that they have some input into this process, and why at the same time, too much input and control is inconsistent with the protections and values that are sort of foundational to the justice system as we understand it today. And there's been two recent cases that I just wanted to throw out, and I don't want to talk too long because I want some time for discussion, where I feel like this highlights this tension about victims that sort of plays throughout this entire issue. And the first involves, and this is an important and difficult issue, a charge that happened from a former Towson University student. This has been in the news, where she alleged that 3 baseball players from the University of Maryland, Baltimore County had sexually assaulted her and a friend. After taking the case to the police, the state's attorney in Baltimore County ultimately declined to pursue a prosecution in that case. So it was the victim who then went and got a application for statement of charges to initiate the case. The county commissioner took that, evaluated, and went and spoke with the state prosecutor, and after speaking with the state's prosecutor, declined to pursue the case. The victim then filed a second application with a different court commissioner, and that commissioner did in fact find probable cause and issued a summons. So the question then was, what will happen next? And what happened next is the detectives who were asked to serve the warrant refused. And the state prosecutor ultimately said that they were going to decline, and it went farther, and there's allegations that the state prosecutor sent police officers to the student's house and said, you are exposing yourself to potential charges if you continue to file these cases. And there is now a lawsuit that relates to that in Baltimore County. I bring it up to focus on the fact that we wrestle with how much control a victim should have in pursuing a case versus the degree to which the state's attorney properly acts as a filter on these cases. A second case that's been in the news in Maryland that highlights the difficult question of the role that victims play in prosecutions involves a recent plea deal. And it's important to recognize that while Maryland law no longer allows a private prosecution where a victim simply pursues the entire case, there actually is a lot of law that creates rights for victims and involvement in the criminal process. And in fact, the Article 47 of the Declaration of Rights includes protections for victims, and Title 11 of the Maryland Criminal Procedure has a variety of rights, including the right to be heard before sentencing, the right to be heard before there's a plea, and a variety of rights to be notified and have a say if there's a motion for reconsideration of the sentence and things like that. So in this particular case, the defendant, it's been in the news, was Luther Trent. He admitted that he went to his ex-girlfriend's house, and while she and 2 roommates were asleep, attempted to burn the place down. Trent was facing 18 felony counts, including attempted murder and arson. And at a hearing on the case, when the victim was not present, was offered a plea deal to time served and a suspended 10-year sentence, which he accepted and which the court accepted, and he was sentenced. The question was, the victim had rights in the case to be heard before the defendant was sentenced. So what was the solution? What role does a victim have once a defendant has already been sentenced? Well, the victim went out and got her own attorney, came to court, challenged the sentence, and ultimately the judge agreed. The sentence was vacated, it was thrown out, and the attorney for the victim is now arguing that the defendant should get 25 years in jail. I bring this up to say that the pendulum continues to swing on how much control and access we give to victims. And I think this book is valuable, John, not simply as a historical study, but I think, frankly, it exposes a constant tension and challenge we have with the degree to which victims get to dictate sort of the path that their case will go through the system, and the degree to which, no, the state ultimately is the one that pursues the charges, and they decide whether or not the case should go forward. So I don't want to keep talking because I want to have a little time for questions, but that was my initial thoughts.
Thanks so much, Dave. And, John, I think we should turn it back to you. You've just heard a lot of people.
Yeah, let's
very deeply.
I wanted to respond to a few things, and I so appreciate all the comments. And I guess I'll start with Roger's comments and going back and looking at the history. And I think it's so important to think about where we've been to think about the moment we're in now. And I think without understanding the history of how we got here, it's very difficult to understand the present. One of the things that hasn't come up yet was thinking about this issue in terms of the implications for discrimination. Back, during the colonial era and before the Civil War and the 14th Amendment and the passage of the Civil Rights Act of 1866, Blacks were routinely excluded from serving as witnesses. And you think about that in the context of private prosecution, that means they couldn't actually bring a prosecution. And so there's a discriminatory element there. But I think understanding the history helps us understand where we are now. And it's so important to think about the connections between like private prosecution and grand juries and private prosecution and like capital cases. Again, the idea of kind of vengeance, and this has informed so much of my work on the death penalty, is trying to understand how we got to this point as well with the death penalty and understanding the origins of prosecution itself and thinking about, one victim's family members bringing a capital charge, bringing an appeal, as it was called back then, to result in the execution of somebody else, direct kind of vengeance in that respect. The one thing that really surprised me, actually, which we also haven't talked about yet, is that when I was looking at this, prosecutors were originally seen as part of the judicial branch. They weren't. I mean, today we think of prosecutors solely as part of the executive branch, but back then they were seen as actually members of the judicial branch. And there's a lot of case law talking about how prosecutors are quasi-judicial in nature. And because they're making decisions about people, their lives, their liberty, maybe, in the case of the death penalty, again, whether or not they're going to be executed or not. And when you think about that, that's a very solemn responsibility. And judges have to be impartial, they're judicial officers, and prosecutors should also have to be impartial. And I think the victims definitely have a big role to play in the criminal justice system in terms of thinking about providing information to the prosecutor's office. But when they start making decisions, it becomes very problematic. And I think so much of what prosecutors do happens outside of the courtroom. So it's not as if you can monitor what's going on. Prosecutors are making plea arrangements. They're deciding on immunity issues. They're making all sorts of decisions about what materials to turn over, Brady materials. And so it's very problematic when you have somebody that's interested in the prosecution making those decisions. And so there's a structural conflict of interest. And this is kind of some of what, Kim's work is so important, thinking about the constitutional accountability, who's actually accountable in these situations. And when you have somebody making decisions behind closed doors about somebody else's liberty and they have an interest, and some of these cases originally there was the person had an interest in a civil litigation matter in addition to the criminal case, which is so highly problematic. And so those are some of the thoughts there. I think, Dave, thinking about the local angle as well is so important because we still see the vestiges of this practice, which again goes back centuries, but we're still seeing it. It plays out in different ways in different states. And I have a kind of a 50-state survey where I looked at in the book of all the different states and the various variations. And we have a split of authority now. Some states don't allow this practice of interested private prosecutions. Some states still do in some form, even in capital cases. We've had cases recently in Texas and Kansas where that's played out in other states as well in death penalty cases. And so I think it's really interesting to kind of think about that in the modern context, as you say, Dave. So maybe we have time for a couple of questions at least, Colin, or?
Unfortunately, we don't. This webinar was scheduled to go to 6 o'clock, and our colleague Gilda Daniels is giving a
that's right,
different book talk right after yours. And so we're going to have to figure out another way, perhaps in person, to continue this conversation. I've just heard from Chris Stutz that we can go over a little bit. And so we can maybe just have 5 more minutes. But we have to be mindful of our colleague and her book as well. So is there another point that you want to discuss? I saw that. No,
I'm done with my remarks. I thought if there was any questions, we could.
The one comes from Mardine, so perhaps we should read it. Okay. He says, picking up on Dave's point about victims' rights, recently the defendants convicted in Georgia State Court for murdering Ahmaud Arbery were prepared to plead guilty to federal charges. The government was initially satisfied with that result, but the court refused to accept the pleas after Arbery's family objected. Is that a form of private prosecution? If a victim's family has veto power over a plea agreement, do those defendants have a due process claim? So perhaps you can give us a little thought on that, and then we'll wrap it up.
Yeah, I mean, I think anytime you've got a private actor who has an interest in a case, who has a veto power or has the ability to make a decision, I would call that something that would raise due process concerns. Again, the public prosecutor is supposed to serve the public interest, supposed to be minister of justice. They're supposed to represent not just the victim, but also, be worried about wrongful convictions, and what can happen there. And so if you've got somebody that's paid to represent the victim's family or private interest, who's also thinking about making decisions, generally that's a structural problem in my view, and is problematic under the due process clause.
Great. Well, thank you. And I will call it for us, so we stick to the regular schedule. But this really is the beginning of a longer conversation. And as Roger and Kim have specifically pointed out, and Dave echoed, this is a book that people will be returning to, and it will be part of many future conversations, both on scholars and people interested in the practical implications of what you're talking about. So thank you to you, John. Congratulations again. Thank you to all of our panelists. There's some great stuff acknowledging this talk in the chat. So thanks to everyone else for participating. And we'll see you the next time.
Thank you.